We are trying to get on. This is the House Judiciary Committee. It is Thursday the 20th. It's voting list number 3. We're going to have a voting session here, and in a moment we're going to speak to a couple of people who are shadowing delegates today, but let's go ahead with the voting. There are 3 bills, House Bill 810, 1011, and 1382 that were all withdrawn. Could I have a motion on the withdrawn bills, please? There's a motion for an unfavorable and a second. Is there any discussion on the unfavorable motion as these bills are being withdrawn? Seeing none, all in favor of the unfavorable motion, let's raise your hands. Let's just do that. Anybody opposed to the unfavorable motion? Seeing none, thank you very much. Those bills are withdrawn. We're going to start then with House Bill 88. House Bill 88 is Delegate Cardin's bill. It went through the Civil Subcommittee. And there's a motion for a favorable and a second. On the bill, is there any discussion related to House Bill 88?
I don't know about that sponsor, but you know.
It's a questionable sponsor. We're going to see it again. Just, you know, it's challenging. It's challenging. He passed out these hats. No one understood why. It's fine. It's fine. All right. You didn't get a hat?
She was out sick.
I would. Look, I think sometimes it's easy to respond and react quickly. Sometimes you should let it really sit in the pit of your stomach for a while and see what happens. Oh boy, it's going to be a fun one. All right. They're always fun. Seeing no discussion on the bill, the vice chair is, we have been trading this cold back and forth with each other. It has been between the two of us, back and forth. We just have boxes of tissues here just because. And 6 feet. It is 6, okay. Great. And so we will get on with it. The vice chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson?
Yes.
Yes. Embry?
Yes.
Yes. Pasteur? Yes. Do we need to pass out some more salt for people today, or are we salty enough as it is? Tolles? Yes. Schmidt? Yes. Simmons?
Yes.
Yes. Boucher? Yes. Partially unwilling. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Excused? Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. All right. Favorable motion is adopted. And we'll go on now to administration bill, House Bill 136. I don't believe there are amendments. No amendments. It's a motion for a favorable and a second. So the bill. Okay. It allows I think it's this is the money for the sexual assault exam kits, and it changes language from this Criminal Injuries Compensation Board, where the money would be coming from, to the Governor's Office of Crime Prevention and Policy.
Oh, I remember this bill,
Yes, so it makes just a change in who's paying the bill, basically. Am I right? Yes. Second time today. All right, there's a motion and a second for a favorable. Are there any questions or any further comments about House Bill 136? Seeing none. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson?
Yes.
Yes. Embry?
Yes.
Yes. Pasteur?
Yes.
Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Simmons?
Yes.
Yes. Boucher?
Yes.
Yes. Phillips?
Yes.
Yes. Congolo?
Yes.
Yes. Erican? Yes. Taylor? Yes. Simpson?
Yes.
Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. All right, the motion for a favorable is in fact adopted. Okay, 146, again, a Cardin bill. I know. This came out of the Civil Subcommittee, and I believe it came out unanimously out of the Civil Subcommittee. Is there a motion? There's a motion for a favorable in a second. We're on the bill. With a favorable motion, are there questions about the bill, or anybody want to talk about the bill? Anybody have any questions about the bill? Any have any thoughts? Okay, the Vice Chair.
What's up with all these Cardin bills?
It's the last one. It's the last one today.
I'm only joking. Yes.
Yes. Are you? Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? E. Kaufman?
Yes.
Yes. Williams? All right. All right, now we're go to something different. House Bill 179, organized retail theft, everybody. There are no amendments. Motion is for a favorable and a second. Is there discussion on the bill? I'm sorry? Delegate Cardin.
Thank you. Thank you, Mr. Chair. I'm going to support this legislation because it seems like there's really not a whole lot of opposition, but I think it's not really a workable situation, and I will be interested to see if there's a time in the near future they come back and ask us for something else because this isn't working. But I will do it because it seems like they're going to give it a shot. I'm just going to say that.
Anyone else? All right. Seeing none, we have a motion for a favorable. The Vice Chair.
Yes.
Yes. Valentine.
Yes.
Yes. Crutchfield.
Yes.
Yes. Cardin.
Yes.
Yes. Tomlinson. Yes. Embry. Yes. Pasteur. Yes. Tolles. Are you sure? All right. Schmidt.
Yes, is there any way to add?
No, it wasn't amended. No, it's clean. So Schmidt is yes. Simmons?
Yes.
Yes. Boucher?
Isn't that so? Yes.
Yes. Phillips?
Yes.
Yes. Congolo?
Yes.
Yes. Erican?
Yes.
Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams? All right. That's House Bill 179. That one will be Delegate Tolles going to the floor. I should have mentioned 88, 146, Delegate Cardin to the floor. I should be doing this as I go along the way. And 136 will be me for now, depending on how the Vice Chair feels. 249 is Delegate Polakovich-Carr's bill. There's a question about what?
I just want to thank you for working with me over the past couple years for HB 179. Just
Okay.
wanted to thank you for that publicly.
You're welcome. That's fine. I appreciate it. So we're now on 249. There are no amendments to 249.
Move favorable, Mr. Chairman.
Am I looking the right way?
Yes.
Yes.
No, to me, but there's
Oh, it's you?
Yes.
Came out of subcommittee. There are no amendments. There's a motion for a favorable and a second. Delegate Conaway. So Holly, can you help with the description of this again?
Sure. So in 2023, there was chapter 768 and 769 that prohibited local ordinances and municipalities from enacting laws that dealt with summoning law enforcement and emergency services. But it only said enacting. it didn't say enforce. And so right now, if you go to the text of the bill, they needed to fix that presumption. So it should have already, it was an error, an oversight. It should say the governing body of a county or municipality may not enact or enforce. Because right now, it only says enact, but some of these local municipalities are still enforcing these laws that are prohibited. So it's cleaning it up.
And the prohibited laws are an example of the prohibited.
So there's a whole list. Hold on.
I mean, if you just name.
Oh, go ahead.
Delegate Kaufman.
Well, Delegate Conaway, what happens a lot is that people like me who fall sometimes and different things like that end up, not so much me, but my friends end up having to call 911 more than the average person. And what's happening is that there are some severe consequences that are happening to the disability community. And, you know, grandma and grandpa who have to call 911 and they get, because if Ms. Vandergraft is correct, they're like consequences and potentially, you know, you could get thrown out of your apartment if you call 911 too much and different things like that.
Thank you very much.
Is that correct, Ms. Vandergraft?
Yes.
Thank you so very much.
Just a reminder that serving on this committee does not actually help you get a law degree. You do have to go to law school to get that. But I am constantly and really sincerely, you all, there are lawyers here, there are not lawyers here, and there's this distinction sometimes that we make. I feel like everybody picks up on this way more than everybody gives credit for. And so I'm just saying, that just happened. Okay, where 2 years ago he had a cheat sheet in front of him with legal terms. Now he's explaining one of the bills that we've got that's not necessarily an easy concept to deal with. I'm not sure. We're going to stick with the positive right now, however, and it's a favorable here. And I'm not sure what that sounded like. I don't mean any disrespect. I just credit to Delegate Kaufman and to everybody in that sometimes, you know, this is kind of cool. All right, House Bill 249, there's a favorable and a second. Anything else? I'm sorry, Delegate Schmidt.
Thank you, Chair. I've looked at some of the testimony. I just want to kind of highlight some of that. I think there was, I know it's clearing up some legal term that we talked about last year that we passed, but I know I think it was regarding the cap on local jurisdictions on the amount of times that they're getting called for the properties. Is that the way that I understand it? If they were over a certain amount of times that the owners were being fined? So if I read, this legislation restricted the ability of local governments to penalize tenants and landlords from using the local emergency services. Some local governments capped the number of service calls to specific properties. If a property exceeded the cap, the owner could be fined hundreds of dollars. I know we had some of these issues in a lot of the college towns where if they were being called for noise ordinances over and over and over again, I guess that they were being fined. This removes that statute.
I don't think it goes to the people who were creating the noise or creating the disruption. It goes in the opposite, that if somebody, that there were communities who were penalizing people for making the calls repeatedly,
So not the landlord and the tenant, but on the neighbor, per se?
On the neighbor who is being penalized for, yeah, they're being fined for calling 911 too much.
Okay.
As opposed to the people who, the other way around.
And there are exceptions for excessive noise. There are several exceptions, Delegate. It says the installation and use of security alarms, physical conditions, sanitation, excessive noise, gatherings, social gatherings, parking enforcement. So there are some exceptions in there too.
Okay, all right. I'm going to be a yes on this bill. Thank you.
Tomlinson.
If I had one more minute, I could probably communicate this a lot better. No, in Carroll County, we passed, our county government passed an ordinance because I just want to make sure if we're talking about the same thing, where we have a couple particular stores, it's like 2 Walmarts, one of the makeup stores, was it Ulta? Not Ulta, yeah. Where in Westminster, I think like, I don't know, 75% of the calls or something crazy of calls of our law enforcement was getting called to those stores for them to, I guess, report theft of some sorts. So they passed an ordinance. I'm trying to remember exactly what it did, but it basically was trying to hold these stores accountable that in our view, we're saying you guys need to hire your own security or you need to address these thefts that are happening rather than calling our local police to show up, you know, multiple times a day so you guys can fill out paperwork and, I don't know, I guess go through insurance or whatever. And so what our county commissioners did was they passed some kind of ordinance where I think they're able to fine these stores who are almost taking advantage of repeatedly calling 911. You might know what I'm talking about a little bit, Will. I just didn't know if this bill is going to conflict with that.
It'll impact it at all because this is dealing with residential.
Only residential.
Residential owner, tenant, that type of thing. It's not going to deal with your commercial property.
Nothing commercial.
No.
Okay.
Delegate Grammer?
Thank you, Mr. Chair. So if I recall, the way this bill was discussed, it was for certain apartments where you'd have a particular tenant who would, for whatever reason, call law enforcement over and over and over. And from that point, the apartment complex would adopt some kind of rule saying, this is causing havoc in our complex. We're going to adopt a rule that says we may, discontinue your lease based on certain factors. And what this bill, to my understanding, is doing is saying you can't do that. So it's essentially stepping in between the property owner, the landlord, and the tenant and saying you can't adopt these rules to penalize a tenant or a person staying in a property even if they're calling law enforcement too much. It's just residential.
Seeing none, we have a motion for a favorable and a second. And we'll go to the vice chair.
Yes.
Yes. Valentine?
No.
No. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Simmons? Yes. Boucher? No. Phillips? Yes. Congolo? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right. All right. We will move on now. I lost. No, I didn't. Delegate Embry has a bill. House Bill 281. Delegate Embry, why don't you remind us what the bill does?
Thank you, Chair. So this expands Maryland's existing forfeiture by wrongdoing statute. And forfeiture by wrongdoing means that if a party causes a victim or witness not to be present, and it has to be through wrongdoing, so witness intimidation or, I guess, some corrupt means, which is a crime separately. Witness intimidation is a crime. If they do that, forfeiture by wrongdoing means that the other party, usually the prosecutor, can go to the court and say, I would like to admit their statement if it's recorded under as defined, so that they don't have to dismiss the case because the victim or witness is not present. So it currently exists for felonies. This would expand it to second-degree assault, which is consistent with federal law and the vast majority of states, which either by statute or rule follow it for all crimes. So we would actually still be more restricted because the only misdemeanor would be second-degree assault.
Okay, is there a motion?
No, there's a question.
Motion for favorable and a second. Second, no questions all over. Delegate Valentine.
Thank you, Mr. Chair, and thank you, Delegate Embry, for talking to me before this about this particular topic. So just so I can clarify, in order for this exception to be made, they would have already met the threshold to be qualified for being charged with intimidation of a witness prior That's okay. Where before, they would only be able to be charged that way, but they would lose the second-degree assault. This gives you the ability to not only charge with a witness intimidation, but also possibly as well prosecute the second-degree assault. Okay. Thank you.
Conaway?
Yes, sir.
Thank you, Mr. Chair. So I'm just trying to understand what the bill probably does. Is this going to be the vast majority of these, the vast majority of these cases are going to be DV cases where the person committing the assault has basically in some way got the person to not be unwilling to cooperate with the investigation anymore, and the statement you're trying to bring in is a statement they previously made to law enforcement?
This is motivated, this came from the state's attorneys, the special victim prosecutors, because it's rare to have the proof, but when they have the proof that the reason a victim didn't come is because the person who already harmed them and committed second-degree assault against them has now threatened them, harming them again, and that's the reason they're not there. It's to allow that police, the statement made, and it's defined, it has to be recorded in some manner to be used in the secondary assault trial.
Is there any other large category of case type that I'm not thinking of here? Where this
Secondary
might be...
assault covers a lot, as you know, covers a lot of ground, so it would be usable in other cases. But again, you'd have to have proof, which is hard to get.
Yeah, okay, thank you.
Thank you, Mr. Chair. So first of all, the statement happened prior to the intimidation, right?
Correct.
And it's already there, and it was part of the case originally. Yes. You think that the person's going to come testify, but then they say, no, I'm not going to come testify.
Yeah, I mean, if you even know that, and then you could get a body warrant, you can still try to bring them to court, but if you can't find them.
Right. And is there a separate hearing? I remember this was in part, there's a separate hearing to determine whether the evidence can be admitted.
Correct, and it's a preponderance of the evidence standard.
Okay. And it's not required, though, to proceed on as Valentine was saying, on a intimidation or other kind of charge?
Nothing's required. That's just an option.
Okay. Thank you.
Anyone else? There's a motion and a second for a favorable. If there's no further discussion, the vice chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden?
Yes.
Yes. Tomlinson? Yes. Embry?
Yes.
Yes. Pasteur? Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? I tried. Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Pardon me, the favorable motion is adopted. All right, House Bill 353.
Mr.
There's a
Chair.
motion for Delegate Bartlett, Vice Chair.
2 questions. I could have texted you, but do you have cough drops?
Yes, I do have cough drops. Thank you very much.
And do you have water?
I have water and cough drops. Thank you very much.
Great.
We have a supply of cough drops that sit right here, along with we have Kleenex, and yes. Okay, we're back on House Bill 353, where there's a motion for an unfavorable and a second. Is there discussion on the unfavorable motion? Delegate Grammer.
Thank you, Mr. Chair. So I'll remind the committee what this bill does. This removes the permitting process for carry so that any person who could legally purchase would be able to carry. And I think the current process is frankly prohibitive, and I don't think we should charge people to exercise a right. We've heard lots of arguments from advocates about the expansion of carry and how it creates this public safety hazard. Not only do I not agree with that, I think from the testimony we've heard from the state police over the last several years, the numbers prove that to be untrue. So me personally, I'd rather be exposed to the inconveniences of attending to too much liberty than those attending to a too small degree of it. But I think we should frankly empower people who are law-abiding citizens and allow them to exercise their right to self-defense without a burdensome and expensive process. So I would oppose the unfavorable motion.
That a yes is for an unfavorable.
Correct. Correct. A yes is for an unfavorable vote here. So if you're voting for the unfavorable, you're voting against the bill. Delegate Tolles.
Thank you, Mr. Chair. I just want to confirm, is this the bill that, where the law enforcement came in and said they wanted to go from the 3 years to 5 years? No. Okay. Okay.
This would eliminate the handgun permit requirement in the state of Maryland.
Okay.
It would eliminate the handgun permit requirement that we have in the state of Maryland. Delegate Tolles, and then I'm coming.
I will be voting against this bill. I think we need to have some parameters in place. Thank you, Mr. Chair.
Thank you. Delegate Conaway.
Thank you, Mr. Chairman. I had a conversation with the maker of the bill, and based on the conversation, I put an amendment that said that you still had to have the training in order to carry without the permit. But the amendment is not here at the time. I know what the motion, yes, sir. Thank you. I just wanted to explain that.
All right, we're on an unfavorable motion. Seeing no further discussion. All right, on the unfavorable, the vice chair.
I am voting yes on the unfavorable motion on the bill so that the bill does not move. Thank you, Mr. Chair.
Thank you. Delegate Valentine.
No.
No. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? No. Phillips? Yes. Congolo? No. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? No. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? The unfavorable motion is adopted. All right, we're going now to House Bill 616. Delegate Hutchison. And just as a note before we begin and before I take a motion on this, Delegate Simmons is working on a number of different pieces of legislation regarding to issues related to cemeteries and issues surrounding that. I don't view this bill as necessarily preempting any of those bills. In fact, one of his bills has a change to the statute of limitations, I think, in it already. So it's at the moment, we have this here in front of us, but we're still going to consider the other cemetery bills that Delegate Simmons has. There's a motion for a favorable and a second. Are there further questions or anything regarding this legislation? You know, questions or anything?
Mr. Chair.
Yes, Delegate Williams.
Mr. Chair, there was a version of this bill last year,
I
correct?
think we passed this last year.
Okay.
We did. Same bill. Anybody else? All right. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Arakan? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. That's House Bill 616. Now we have a couple bills from the people down the street at the Judiciary. Oh. I don't have the folder. I don't have the folder. 646. 646 extends the length of time for the task force that we already created last year. It extends it, I think, a year, if I'm not mistaken, correct? So it gives them more times to work. There's a motion for a favorable, and there's a second. All right. And are there questions? Delegate Valentine.
Just one question. There is no additional fiscal implications, correct?
They have existing resources.
Thank you.
If I'm not mistaken. Okay. Anybody else? All right. On the favorable motion, the vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? No. Taylor?
Yes.
You need to lobby your neighbor better. All right, Taylor is a yes. Simpson? Yes. Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
All right. Now, three bills from the judiciary. The first bill allows the Appellate Court of Maryland, and there is an amendment. There's an amendment that makes a clarifying change in the bill. And it's 623323, amendment number 1. It's, what does it do?
It's just technical.
It is a technical. Holly, tell us what, yeah.
So when the bill was initially drafted, it should have said on page 1, line 15, except as provided in paragraph 2 and 3, because of the new provisions that are in paragraph 3 related to the secondary and post-secondary education. So it's just a technical amendment cleaning up that subsection A1.
There's a motion for the amendment. Is there a second?
Second.
Any discussion on the amendment? Amendment number 623323 on House Bill 786. Anyone else? Seeing none, all in favor of the amendment, please raise your hands. Anybody opposed? Madam Vice Chair, were you opposed? Oh, no, we're going to now for a tour of the Vice Chair's home. She's for it, okay. The amendment's adopted. There's a motion for a favorable. Is there a second?
Second.
Second, thank you very much. Again, this bill will allow the Appellate Court of Maryland to go to high schools and to post-secondary educational institutions and literally hold court. So I think it's an interesting expansion of some of the things that they're already doing. So I'm pretty excited about it, I guess. Yes. Delegate Williams.
Yeah, I just wanted to say, Mr. Chair, I'm so excited about this bill. When the Judiciary started to do this, the first place that they came was to Flowers High School in Prince George's County, Maryland. It's located in District 25. And so I think everyone really enjoyed the experience, and so I'm glad that we're expanding this.
Delegate Simmons.
Yes, sir, Mr. Chair. I just want to also echo that. I think this is wonderful that the court is doing this. I know the chief judge has been out to high schools and going around with some folks from the judiciary. So I encourage all our members to partner with our judges as they're going out, especially in your districts. I think you can also invite them out to your districts to do this as well with the schools. So we need to be more engaging on that level as well. Thank you.
Delegate Boucher.
This is expanded to the former Court of Special Appeals to do it. So it includes the state Supreme Court and the what used to be the
Yes.
Court of Special Appeals.
This is, it
Gotcha.
used to be the special appeals, now it is the intermediate court.
Gotcha. I just wanted to clarify.
Because someone relented many years ago. Delegate Tolles.
Thank you. I know Delegate Williams' fault, but no, she got us started. But no, I just want to quickly pile on and say, to add another layer to that, I had an opportunity to have some of my students from Bowie State University in the hearings that were taking place, or the what is the actual legal term, but the court proceedings that was taking place. And it really encouraged the individuals. It was part of the criminal justice department where I teach, and those individuals, those students were so pleased and interested in the topic. And so I just want to add on that it is such a good experience, not just for our high school students, but, you know, for some of our college students, undergrads who are considering law school, to see that firsthand. So I would like, since we have an amendment to also be added on, I think it's a great experience.
But it's a chair bill.
Oh, you
and
can.
it's effectively an administration bill. Can we do that? I don't think we can.
Put it afterwards,
No.
because I think we have it for the St. Mary's.
We also have it for the St. Mary's bill, so sure. If you want to pile on to Hunter, just bait a face, but just don't pay attention to Hunter. So we can add on if you would like to, and what might be easier, well, we'll just do it when we go around and it'll be fine, and I'll make a mark on it.
Thank you, Mr. Chair. Sorry.
You bet. No, it's all right. Hunter, you know, he just lies in wait. Delegate Schmidt.
The Judiciary Committee can hear hearings outside of the.
We have done that in the past. It is not impossible for us to do these things, but we would have to be in session and would have to uproot everybody to go somewhere else. Delegate Cardin, we should go to the shore.
When we were debating casinos in Maryland, the Ways and Means Committee went all over to each jurisdiction and had a hearing in every single jurisdiction. Some of them lasted till after midnight.
But it was in the interim, right? It wasn't.
That was in the interim, but they were official hearings that were given, we were given the authority to do. I will say, while I understand the good ideas here, I think that our justices, I think that's what we call them now, they can go out to jurisdictions anytime they want and visit, and we would love to have them come to Baltimore County sometime. So, in fact, we have some of the appellate judges who their offices reside in Baltimore County, and we'd love that. So,
all right. We all really like this bill. House Bill 786, there's a motion for a favorable and a second as amended. Any further discussion? Seeing none. The Vice Chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes, and add.
Yes, and an add. Carden? Yes, and an add. No add. Just a yes. Tomlinson? Yes. Embry? Yes, and an add. Pasteur? Yes. Tolles? Yes, and an add. Schmidt? Yes, and add. Simmons? Yes, and add. Boucher? Yes, and an add. Phillips? Yes, and add. Congolo? Yes. Erican? Yes, and an add. Taylor? Yes, and an Erican. Simpson? Yes, and an Erican. Grammer? Yes. Sample Hughes? Sample Hughes. And add. Sample Hughes and an add. Moon? Yes. Conaway? Yes, and add. Kaufman? Yes, and add. Williams? Yes, and an add. Chair votes aye. All right. So that's 786. Now 787, maybe a little more arcane, a little more technical, but House Bill 787 does not have an amendment. Could we, I think it does two things. I think it makes a language change.
It's just a repeal.
And it's a repeal, it's a repeal of their requirement that they have to get it copyrighted?
Because it's obsolete.
Oh, it's an obsolete reference that's in the law. So it's basically eliminating an obsolete reference. Delegate Conaway. We aren't, well, actually, let's take the motion and then we'll get to the bill. Is motion for a favorable, is there a second? Second. All right, done. Now, Delegate Conaway.
Yes, I'm dealing with a situation somewhat similar to this. Why is the copyright obsolete?
Counsel.
Please.
So, the U.S., this is in the fiscal note, but the U.S. Supreme Court in Banks versus Manchester ruled that copyright law does not apply to judicial opinions. And then that most recently was affirmed in a recent U.S. Supreme Court case, Georgia versus Public Resource from 2020, which basically says that the opinions constitute authentic interpretation of the law that are binding on all citizens and free for publication of all, so no copyright is needed.
Thank you.
You're welcome.
Okay. Are there further questions on the bill? There's a motion for a favorable and a second. Seeing none, the vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden? Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. That is a favorable motion on 787. So now we're going to go to House Bill 864. House Bill 864 changes the number of circuit court judges in St. Mary's County from 3 to 4. There's a motion for a favorable and a second. There are no amendments to the bill, straight favorable. Is there discussion on the bill? Circuit. Adding one circuit court judge to St. Mary's. Seeing none, no more comments or, okay. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Carden?
They want them, give them to them.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. That concludes the voting session for the 20th of February. It's 12:48. We need to give staff about 20 minutes to get ready for the hearing.